Ladies and gentlemen, distinguished guests, and valued members of National Cannabis Industry Association, welcome to today's Industry Essentials educational webinar and the return of our Fireside Chats with NCIA's Government Relations team. I'm Brian Gilbert, and I'm thrilled to kick off this Fireside Chat session titled HHS Recommends Rescheduling. Now what? As part of NCIA's Industry Essentials webinar series, our commitment to providing you with timely, engaging, and essential education has never been stronger. And today's Fireside Chat is a prime example of how we bring you the latest developments in federal cannabis policy live and direct. So, for more than 5 decades, cannabis has been classified as a Schedule I drug by the federal government. But as we stand at this pivotal moment, the recent recommendations by the Department of HHS to reclassify cannabis to Schedule III is going to be a game changer. And we're here to explore what this historic shift means for you and the future of your business. So what's next? How will it impact our industry? Today, we have the privilege of hearing from 2 of NCIA's foremost government relations experts, NCIA's own co-founder and CEO, Aaron Smith, as well as Michelle Rutter-Freeberg, our Director of Government Relations. I encourage you all, as always, to ask questions and make the most of this invaluable interactive educational opportunity. So with that, let's turn it right over to Michelle and Aaron, to dive into this conversation and uncover the insights that will help shape the future of the cannabis industry. Without further ado, I'll turn it over to you, Michelle, and we'll get this party started.
Thanks so much, Brian. I saw you almost say Mike and Michelle. We're still missing Mike Correa here, and we're used to our team, but happy to be joined here by Aaron today. Hello, everybody. It is wonderful to virtually be with you all. Happy to see so many friendly names. I would say friendly faces, but friendly names that could attend today, and happy to see some new ones too, and excited to educate you guys on some of the latest that's coming here out of Washington, D.C. A couple things on the top here. I want to let you all know, make sure you use the Q&A feature at the bottom of your screen. We are going to be doing a lot of Q&A today. We want to make sure that we are answering questions that you all have. We've also collected some questions ahead of time so that we can answer some of those here as well, but want to make sure that you guys are aware that we do have that Q&A feature. You also have the ability to actually upvote other people's questions as well. So if someone beat you to the punch and is asking what you wanted to ask, make sure you hit that upvote, and so we'll make sure that we see it and can get to that. I also want to make sure that you guys are aware that there's a lot to unpack on this topic, and I think personally there's a lot of uncertainty because I sort of err on the side of caution here. But with that being said, Aaron and I are going to talk a lot about what's happened, what we think could be next. We're going to talk a lot about political implications and what's going on sort of in the politics of this. But I want to refer to you guys, in the beginning of October, NCIA is going to be continuing our Policy Matters series, which just kicked off actually a couple weeks ago with the Maryland regulator of cannabis, Will Tilburg. Next month, we're going to be talking with John Hudak, who is a regulator out of the state of Maine, also formerly with the Brookings Institute, as well as hopefully a special congressional guest to unpack sort of some of the more policy wonky parts of this discussion. So if you're here for the politics, you got us today. And if you're also looking to hear some more about the policy and get into the legalese of all of these implications, you'll want to make sure that you sign up for that session. That, again, will be happening in the beginning of October. And I'm sure that if you got the email for this, you will see the email for that session as well. So now that we got our housekeeping out of here, Aaron, hello. I'm going to keep talking for a moment and give everybody sort of the lay of the land of what's happened. So I'm sure all of you are aware that at the end of last month, the end of August, the Department of Health and Human Services issued a recommendation to the DEA about where cannabis should be classified in the Controlled Substances Act. But backing up from that a little bit, I just want to remind everybody how we even got to that moment. So last October, President Biden issued an announcement saying that he was going to begin the process of making good on some of his campaign promises around cannabis. And that included both the expungement of records, as well as initiating this process to, again, review where marijuana is scheduled under federal law. So that happened in last October. And since then, it's sort of been quiet. But I will say, HHS making a recommendation in a matter of months, it wasn't even a year, I think, 10, 11 months, is pretty monumental. So what happened? As I mentioned, the Department of Health and Human Services recommended to the Drug Enforcement Administration, or DEA, that marijuana be rescheduled from Schedule 1 to Schedule 3 under the Controlled Substances Act. I want to go off and say a couple things about that first before I even dive in more on that. First off, it's important to note that nobody in the public, at least I should say, has seen this letter or this recommendation yet. So this has been reported widely in the news. It has been confirmed, at least in loose terms, by agency officials, but nobody has actually laid eyes on this recommendation. So I think that just like a lot of things, the devil is in the details. And I certainly know that I am not the only one who would like to get their eyes on that letter. So I think that's really important to mention. And I think it's also really important to mention that this was just what I said it was. It was a recommendation. And so this recommendation was based on the FDA, the Food and Drug Administration's review of marijuana. Again, that was requested by the president in 2022. And I also think it's important to note that DEA has actually testified before Congress about this issue. And back in 2020, they were asked, essentially, would you be bound by FDA's recommendation, regarding some of the scientific and medical matters? And so, and they said yes. So that doesn't mean necessarily that, that's all said and done. And because FDA said so, or HHS said so, that again, that DEA is required to do that. But again, very just important to say that there are some things on the record that are sort of guiding what we're thinking right now. So what is Schedule 3? The Schedule 3 means that the drug or other substance, in this case, cannabis, has a potential for abuse that is less than the drugs in Schedule 1 or 2. But really the meat of this, it means that the abuse of cannabis may lead to either moderate or low physical dependence or high psychological dependence. And Aaron, that's a lot different than what Schedule 1 means, right? And where we are now. That would be a pretty big improvement, wouldn't you agree?
Well, yeah, absolutely. It's made no sense that cannabis has been listed as a Schedule 1 substance since the very day it was put in that classification, as there's mountains of scientific evidence to the contrary that around medical efficacy and the potential for abuse.
Yeah, and like I mentioned earlier, it's quite a process in determining where a drug schedule or what a drug schedule should be. So, like I mentioned, the president initiated this review, and so what happens when when that begins? The review includes several steps. So, first off, the review has to be requested. Okay, check. We have that. So next, the HHS through the FDA evaluates the drug and its schedule through what's called the 8-factor analysis. And so what is the 8-factor analysis, you ask? Well, the 8-factor analysis looks at the drug's actual or relative potential for abuse, the scientific evidence of its pharmacological effect, if known, the state of current scientific knowledge regarding the drug or other substance, its history and current pattern of abuse, the scope, duration, and significance of abuse, what, if any, risk there is to public health, its psychic or psychic. I guess it does mean psychic. I'm reading this from the DEA's website, you guys, and I'm like, psychic, sorry. It's psychic or physiological dependence liability, and whether the substance is an immediate precursor of a substance already controlled. So a lot to unpack there. So again, HHS looks at that 8-factor analysis and then makes a recommendation to DEA based on that evidence. So that's where we're at right now in this process. So next up, the DEA is going to conduct its own review with HHS's recommendation in mind. And the DEA is going to look at the 8-factor analysis as well. But I think it's also really important to realize that the way that the law that this is written says that the DEA will review FDA's recommendations and its own findings and any other relevant facts to determine the proper scheduling of cannabis. And again, I think that really is where the devil is in the details here. When HHS does its 8-factor analysis, it does not get to consider all other relevant factors where DEA does. So I think that that's just an important determination here when we're talking about this. So as I mentioned, the DEA is going to conduct its own review with HHS's determination in mind and set the final schedule. So once they do that, there will be a public comment period that opens up. But Aaron, I want to talk to you a little bit just about again, what does moving marijuana or cannabis from Schedule 1 to Schedule 3 look like? Can you talk a little bit about some of the real world impacts of that?
Yeah. So, I want to say for one, start this off, say this is a monumental move. And if and when cannabis is moved from 1 to 3, it will be the biggest step forward for the industry, probably since the first day that we had legal cannabis sales in Colorado in 2014. But with that said, it is not the end all be all. This is not going to align federal and state law. What will happen is you will have state-based industries as we have today that will be now trafficking in a Schedule 3 controlled substance illegally. Schedule 3 substances, the only way to manufacture and distribute these substances is going through the FDA new drug approval process, which is a $1 billion endeavor in some cases, and then dispensing medicine through pharmacies. But we talked. You said at the top of this, you said this is there's a lot of politics around this, and the politics are incredibly positive for the industry. The fact that this is coming straight from the White House, that this is in a very moderate Democratic White House, is a result of decades of advocacy work that has been done, and the success of this industry really just showing the country that cannabis is better off regulated behind a regulated counter than in the underground market. And while there will be still a lot of work to do, we still need to get banking, we still need to protect the industry from the mountain of Food, Drug, and Cosmetic Act regulations that could be imposed on us. The fact that this, for one, changes 280E, it gets rid of 280E for the industry, which is a huge step forward, to say the least.
No, undoubtedly. And I know that one of our questions that had been posed to us before the session started was about 280E, and could the 280E relief, or the lifting of 280E rather, be applied differently to medical businesses versus adult use businesses? And the answer is no, correct, Darren?
No, I mean, 280E, interestingly, the statute just says it applies to illegal trafficking of Schedule 1 or 2 substances. So illegal trafficking of Schedule 3 substances, you can deduct all the expenses associated with that. It's a strange provision in the tax code, always has been. But this sort of, one of the, really good prospects of rescheduling. And I think it's important to note that FDA, DEA, HHS, these agencies aren't looking at the tax code implications around rescheduling. They're looking at it, and honestly, they should not be. That's not their purview. But because, from the scientific standpoint, it makes no sense to have natural cannabis as a Schedule 1 and then have synthetically produced THC as a Schedule 3. I think they're looking to resolve that mismatch, and a great outcome, a great result of that will happen to be making 280E a thing of the past for the industry.
Aaron, you set that up perfectly for where I wanted to go next and talk about, again, getting back to some of the next steps in this process. And so, like I mentioned earlier, DEA is going to conduct its own review of cannabis. There is no timeline around this that we're aware of. There is some disagreement in the legal community about whether there is a timeline set on this. But from what we understand, we do not believe that there is a certain amount deadline that DEA must give their answer by. But that being said, when you were talking about synthetic THC and Marinol, Aaron, DEA opts to move forward with rescheduling marijuana to Schedule 3. Again, it's going to do so through the rulemaking process. They're going to issue what they believe should be the schedule, and then open up that for public comment via the Federal Register. Again, when that happens, NCIA members will be activating you to make sure that you are getting your thoughts in. But that being said, we're unaware of any instance where DEA has rejected the FDA recommendation to reschedule. So, for example, back in 1998, FDA recommended to DEA that Marinol be rescheduled to Schedule 3. That's synthetic THC that you were talking about there. And in July 1999, DEA did just that and rescheduled Marinol to Schedule 3. Now, that being said, there was actually a rescheduling petition way more recently than that, Aaron, right? There was one back in 2016, and FDA's recommendation was that cannabis should remain in Schedule 1. And so DEA said, yes, cannabis should remain in Schedule 1. So, Aaron, that was only 7 years ago. Did cannabis's medical efficacy magically change in the last 7 years? Again, getting back to some of the politics here, what do you chalk that up to?
Well, I mean, certainly the science did not change. And what did change was that we now have, a super majority of the country living in a state that has departed from federal law and has an effective medical cannabis law. We have half the country living in an adult use state, and super majority support across the board, across every demographic for this issue. And I think there's been a real shift in the conversation just in these last few years about not just when do we make cannabis legal, or how do we make it's more about how do we make cannabis legal and how are we going to regulate it at the federal level. And this schedule, the rescheduling would just be one step in toward what NCIA has always advocated for, which is descheduling cannabis, removing it from the Controlled Substances Act, and treating it like an adult product similar to alcohol. And I think that I think I saw another question that was posed prior in advance was, there was concern about whether this would be sort of a one and done thing, and that the federal government and Congress could wipe their hands of this and say, oh, we've rescheduled, the marijuana issue is no longer an issue, and we can walk away from this. I would have had that concern if this happened 10 years ago. But I do not share that concern today, because for one, we have an industry that is operating in most states that's out of compliance with federal law and will remain out of compliance with federal law. And because of the education, because frankly, the work you're doing, Michelle, educating members of Congress and the administration and thinkers in DC around this issue, I think they know very well that this is just a step forward, and that the actual solution to the state-federal conflict is descheduling.
Yeah, I couldn't have said that better myself, Aaron. So, again, like we mentioned, there is no timeline. DEA is going to come up with their recommendation. What would you say? I mean, I say there's no timeline, but there really is. And the timeline that I'm talking about isn't necessarily one that's codified in law or regulation, but is the election that is coming next November. And so I think it's obviously likely, the DEA administrator's boss is President Biden, right? So I think that there's a vested effort, or I should say interest there in, making sure that the effort that your boss promised on the campaign trail and is now trying to follow through on through your agency, through your administration rather, moves along quickly. Any thoughts on that?
Yeah, I would share that opinion. I think, I don't know when this will conclude. I don't think it'll be quick. It certainly won't be overnight, or even, I don't think it'll be a matter of weeks or a couple of months. I think we're looking at a long period, because you have administrative review process and public comment period. And the DEA is not they're not a very quick, nimble organization. But you're right. I think we should get some movement before the election. And this is again a political process. The order to the order came directly from the president. When we talk about the last time there was a rescheduling petition, it came from patients. It came from the advocacy community. So
two governors, right? It was two governors at the
time. Two governors, you're right.
Yeah.
And this is very different still than that. This came from their boss. So I think we will. And I also don't, another question I saw out there is what's the likelihood that DEA will just not enact the recommendation? That's certainly a possibility, but I really couldn't imagine a situation where DEA would just decide to go against the recommendation of the FDA. Even though they probably don't like the recommendation, because they are, these are people that make their money locking people up for drugs. They know that the writing's on the wall, and I think that this would have been probably conversations that happened between those agencies that we were unaware of long before this announcement was made.
Yeah, and another thing that I started to hear about and have been doing some more research on here in DC that I don't think is getting talked about enough when we talk about the timeline for this is what's called the Congressional Review Act. And what the Congressional Review Act says, this has been in law for decades now, but what it says is that Congress has 60 legislative days, and I mean that the emphasis on legislative days, to basically invalidate any agency rulemaking. And the reason that I bring this up is because back about a decade ago, there was a moment where congressional Republicans used the Congressional Review Act to strip a bunch of Obama era regulations. And they were able to do that because the time period had run out and the math was just so that they were within their 60 days to do so. And so I think that that's something that we need to consider as well while we're doing this, is that it would make sense for the DEA to actually make sure that their proposed rule came out during this Congress so that we know what we're working with, and that it would make it then more unlikely for a new Congress, potentially a more prohibitionist favorable Congress, to come in and strip those regulations. What do you think about that, Aaron?
Yeah, I mean, I think that's a great point. Great point.
So, Aaron, I would love for you to dive in a little bit too about NCIA's position on this, because this is something that we got a little bit of heat from both sides. I'm of the opinion that when you get a little bit of not backlash, but feedback from two different sides of an issue, that means you must be doing something right. And I do think, we've kind of touched on it a little bit during this. I do think that our position was a little bit more nuanced. Like, again, we're very supportive of the fact that we're making a step in the right direction. While Schedule 3 certainly is not as far as we'd like to go, it does at least lower civil and criminal penalties. Again, I still think that they're exorbitant, and that's certainly not enough to be a proponent of Schedule 3. But can you walk us through a little bit about our position and why we came out the way that we did?
Yeah, I mean, this is unquestionably a step forward, and I've always seen this as an incremental approach to getting. We're not going to see descheduling of cannabis at the federal level overnight, and we're certainly not going to see it from an administrative process. I think anything like that sweeping would have to go through Congress. Congress isn't particularly quick to get anything done these days, and so this is probably the best, the best step forward that we're going to get in the next few years. But with that said, we can't sit back. We're not going to sit back and just claim credit and say, okay, the battle's over. While this was certainly a step forward, we need to make sure that we're using this step forward and as momentum to build toward what we need to get done at the federal level, and whether that that be other incremental legislation like the Safe Banking Act. And I think this will help build quite a bit of momentum in Congress to finally get that over the finish line. Also, to make sure that Congress knows that they need to enact sensible regulations to make sure that cannabis is regulated at the federal level and aligned with the state laws that have enacted adult use. Medical, the Schedule 3 really only applies to medical products, and it doesn't apply to medical marijuana as we know it today. It applies to pharmaceuticalized cannabinoid products, which there's a lane for those products in this country. I think we will see quite a bit of more innovation out of big pharma, frankly, around from cannabis medicines, and I don't think that's a bad thing. But we do need to make sure that natural medicine and whole plant medicine is protected. And so I see this as huge, a huge win for the industry. But we need to use the momentum to get the Safe Banking Act passed, get appropriations riders passed that protect the industry from FDA regulation, the industry as we know it. Get 280E. 280E will go away once this is enacted for the future, but it will not be lifted retroactively. So that's another thing that we need to be working on, is making sure that the folks that were in this industry before the federal government finally caught up to 1990 on marijuana policy, to make sure that those businesses are not continuing to be hit with these unfair tax bills. And so the work is never done. I probably will be saying that the rest of my life, but that's kind of what, and I think that's the nuance around. I have seen some extremes, some people saying, okay, like this is it, this is it for the industry, we've won. And then I've seen people saying, this kind of doom and gloom, this is going to open the door to big pharma and the industry's over. I don't agree with either of those. I think this is very much a positive thing. And we just need to make sure that in our messaging too, that we don't kind of pat ourselves on the back and send the message to Congress and those that like, oh yeah, we finally won, because we haven't. And we need our allies in Congress to continue to be not just as motivated as they were yesterday to fight for the cannabis reform, but more motivated because of this move.
Very well said. Yeah, like potential implications of a move to Schedule 3. And like you said, this really only applies to medical cannabis businesses. But, some of those potential implications mean that, those who manufacture, distribute, dispense, and possess medical marijuana may now be able to do so lawfully, as long as they're doing so lawfully under the Controlled Substances Act. I think another thing that's really interesting here is that states' medical marijuana programs may now be able to comply with the Controlled Substances Act, and they'll still be, subject to the Controlled Substances Act and DEA criminal and regulatory control, but they're also still going to have to comply with federal public health laws like the Federal Food, Drug, and Cosmetic Act, and agricultural laws like the Agricultural Marketing Act of 1946. And I think that, again, that's something that I'm not sure that either everybody is recognizing just yet or is understanding what the potential implications of that are, because, it's my understanding that the way the current Food, Drug, and Cosmetics Act is written is that it could potentially keep smaller state licensed cannabis companies from growing through interstate commerce and might even allow FDA to intervene within state markets for medical and adult use products potentially as well. So again, I think that's, there's still a lot of uncertainty about what that looks like, right?
Yeah, there is. And I think we also, we need to make sure that, advocates in the state level need to make sure in states like, say, Kentucky, or, really conservative states that have recently implemented medical programs, we need to make sure that they don't roll back those programs and say, oh, okay, well, federal, now there's a federally legal lawful path, because the federally lawful path will only apply to, it's not going to apply to whole plant medicine. I cannot imagine a situation where you have, cannabis flower go through the FDA trials, get approved, and then be dispensed through a pharmacy. And so, there needs to be, and again, it's fine to have pharmaceutical products. It's a good thing to have pharmaceutical products, but it's also important that we keep that we keep the natural whole plant medicine available. And I could see this potentially being used as by opponents at the state level to try to roll back the programs in their states, saying, well, we don't need that anymore, at least at the medical side. And because, yes, you can lawfully, and I'll answer Maureen's question because I'm looking there. And hi, Maureen. She's asking, can Schedule 3 designation allow patients to transport cannabis across state lines? And the answer really is no, unless they are carrying an FDA approved medicine with a prescription from their doctor. So which any medical cannabis patient, as we know them today, don't have that. They have recommendations from their doctor, and they're using a product that they didn't buy at a pharmacy. They bought it at a dispensary. And that would be less illegal than what they're doing today, but still illegal. And it would be comparable to anabolic steroids is a comparable substance that's a Schedule 3 substance that you can get arrested for carrying illegally or carrying it without a prescription. And so that's kind of what we're looking at. I think we really need it. And in the media, the media is not very nuanced in their messaging around cannabis. And I think there will be sort of this announcement that, oh, it's legal now for medical use. But it's no more legal than, say, ketamine that you buy, outside of a pharmacy, or anabolic steroids that you buy outside of a pharmacy.
Yeah, and something that I was just talking about the other day that someone pointed out to me that I found is interesting. And again, I'm not a bio or pharma lawyer. I'm just a mere lobbyist. But that I thought was really interesting is that typically when DEA does these scheduling reviews, petitions, decisions, whatever we're talking about, it's one singular component, right? It's something like methamphetamine or amphetamine. This is looking at cannabis as a whole, which has hundreds, of different components, cannabinoids in it that they're trying to sort of put under one umbrella, but it doesn't really necessarily fit for this. And so that's just something that I haven't really heard people talking about as well. And I know, for instance, NCIA's board chair emeritus, Khurshid Khoja, I have his article actually handy right here. I'm going to paste it in for everybody. But I think that he makes a really interesting point in this piece, this op-ed that I just pasted in the chat, which was about the potential for something like a carve out for cannabis, right? For whole plant cannabis from the Food, Drug, and Cosmetic Act, or from some of these other laws, so that our medical and adult use businesses and programs are not disrupted in the way that they could potentially be. Okay, yeah. We have a question in the Q&A that I wanted to talk to you about, Aaron. Harry asked, if cannabis is changed to Schedule 3, would insurance companies cover it for medical use? And I wanted to kind of open that up and look at the question a little bit broader, which is that, and you touched on it earlier, which is, do we still need things like safe banking? Do we still need things like the Claim Act, which deals with insurance, if rescheduling is to happen? What are your thoughts on that?
Yeah, I mean, I wouldn't count on it, because again, the industry would be out of compliance with federal law unless we're talking about, a pharmacy or a pharmaceutical company, which, so I think we do need to keep pushing for the Claim Act. We need to keep pushing for the Safe Banking Act, and even after this is enacted, and back to Khurshid's point about the carve out for whole medicine is absolutely vital, but we also just need a carve out, and it can come in different ways, but a carve out for state legal programs, whether it be medicine, whether it be adult use. We need a carve out, and the carve out could be, come through the statute that says that, this doesn't apply if, state law would supersede in this case, or could come in an appropriations rider that ties the hands of the federal government from spending money enforcing the Food, Drug, and Cosmetic Act against state legal operators, or it could come in the form of a memo from DOJ, FDA, and I think we're working all those avenues, and I think all of those are actually fairly politically achievable in the next couple of years.
And again, it's like you read my mind there, Aaron. Another question that I've been getting from a ton of people since this happened is there going to be a new Cole memo? Is there going to be, Jim Cole isn't the AG anymore, but is there going to be a Garland memo? Is there going to be some sort of new memo, which is, really one of the things that we said about our position, which is that we would be much more amenable to Schedule 3 with something like an enforcement memo, right? Like, I think one of the biggest things, certainly, we talked about 280E, but I think one of the next biggest things, and potentially the biggest thing when we're talking about human impact, is about the war on drugs, right? And is about enforcement priorities, and who has the brunt of enforcement fallen on, before regulated sales happened, even now under, state regulated sales, and potentially moving forward into a Schedule 3 world. Again, doesn't take much to figure out who is likely going to bear the brunt of that. Black and brown people, and women-owned businesses, small businesses, minority-owned businesses. What are your thoughts on a new enforcement memo? What does something like that need to include? And again, getting back to the politics of things, does it even really matter? Because as we know, a memo can be torn up at the discretion of the next attorney general.
Yeah, I think it matters, and I think that it's likely that a memo like that would come out from DOJ under this administration, because again, the politics of this was that the president is under pressure to do something to be seen as relaxing cannabis laws. If he it orders rescheduling happens, and then it backfires and turns into a crackdown from the FDA. Well, that certainly wouldn't be a favorable outcome for what they're looking for. So I think they're going to clarify, if I were to bet, there would be some clarification from DOJ around this, and that's so that it doesn't upend state markets. And while, nobody really knows what's going to happen, some might tell you they do, that they don't. But that would be, my sense on the issue. But yes, it can, a memo can be torn up, and we could have President DeSantis or God forbid, any of those on the other side there, that would have a very different approach to cannabis. And they could, very well, a lot of things could happen. They could tear up the memo and decide to use FDA's enforcement power to, I think, quietly upend the industry. I don't think I doubt we'll be seeing, SWAT team style raids on dispensaries like we did, 15 so years ago. But I think they could be sending letters out saying that you're out of compliance and really putting the screws to the industry that way. That's something that, is not out of the, outside of the possibility for a Republican administration in the future. I'll preface that with saying that I'm actually pretty hopeful that even under a Republican administration, we won't see too much disruption because, you can see under the Trump administration, yes, they rescinded the Cole memo. They appointed Jeff Sessions. He appointed Jeff Sessions, who hated cannabis, with a passion, rescinded that memo because they were rescinding everything Obama had done that was good. But they didn't on the ground. They really didn't change. There were, the industry grew faster under Trump than under any other administration.
Not because of him, let's be clear.
Not because of him, no.
Causation, correlation are not.
Yes, thank you for that. Yeah, and so I think the likelihood is that's because the politics are what they are is not likely to happen. But I do think that another way to tie the hands on enforcement is through the budget appropriations process. I guess I'd ask you, Michelle. I'm kind of bullish on the prospect of getting some maybe not this cycle, and you can talk to why not, but in the next budgeting cycle, getting something like we have with the Rohrabacher Amendment, which protects medical industry to expand to adult use. But I guess maybe I'll ask you to kind of get into the appropriations process and what that's looking like.
Yeah, well, that's funny. A way to turn it around on me after you said kicking down doors and SWAT teams, I was going to ask you. So great minds. Well, most people here are probably aware. If you're not, since 2014, there's been a provision included in our annual appropriations bills that says that the Department of Justice cannot use any of its funds, so its hands are tied from enforcing federal law on medical marijuana businesses, patients, programs, etc. So what that means is what Aaron alluded to earlier. It meant that medical marijuana businesses no longer, after this amendment was put in place, and it's still in law to this day, medical cannabis businesses didn't need to worry and don't need to worry about the Department of Justice or the feds coming and kicking down their door and taking their product, arresting them, etc. No such provision exists for adult use businesses, though. And again, we're in a very, very different time, certainly, than we were in 2014 in terms of where adult use programs are today. So over the years, there's been a couple different, we've tried to do it a couple different times. It's actually passed the House twice, once under a Republican controlled House, if I'm remembering correctly, and once under a Democratic controlled House. I might even be missing one during COVID because everything is, after being here for 10 years, I'm starting to lose track of all of my counting. But I think that you're exactly right, Aaron, that this a move to Schedule 3, and even just the idea of a move to Schedule 3, I think is going to move lawmakers into going, okay, well, if we're not thrilled about Schedule 3, or we're unsure about what that might mean, or frankly, we do know what that means for adult use businesses, it means they're still completely out of compliance. Why don't we tie the hands of DOJ from enforcing federal law on all cannabis businesses? So I think that is, certainly something that we have worked on for the 10 years that I've been here, and we'll continue working on. Right now, looking at the political I don't know what to call it, looking at Congress as a whole right now, we're having this discussion on September 14th. The fiscal year ends at the end of the month. It ends, I'm like, is there 30 or 31 days? On September 30th, it ends. And so right now we are looking down the barrel of a potential government shutdown because the House Freedom Caucus in particular is playing hardball with Speaker Kevin McCarthy and is, again, threatening to shut the government down. They have not done their appropriations work. The Senate has, the Democratic controlled Senate has, but the House has not. And so currently, I guess that's my very long-winded way of saying that the approps train for this coming fiscal year has already left the station. Now, that being said, we'll still continue. Hopefully they'll do a CR, and there's always, backroom negotiations, especially going on when you're negotiating a large package like the approps bill. So we'll continue to talk to our champions about it. But I think, again, for next appropriation season, and we can start laying that groundwork right now, we're going to be pushing hard for expanding those protections to include all adult use businesses. If you're curious on reading more about this, you can Google the McClintock Blumenauer Norton Amendment, which was the most recent name of it. And again, that's passed multiple times now. But again, Aaron, I don't know if you have any thoughts too, just thinking about what's kind of currently going on here in DC. We're waiting, any minute. I have the Senate Banking Committee website opened up in my email. Obviously, I'm refreshing all the time to see if we're going to have a markup on safe banking. And I'm curious if you think that this news has either sped up, any moves on something like safe banking that's already sort of been teed up for a while.
Yeah, well, first, just before I lose track, I want to go back just a quick touch on appropriations. I want to address a longtime committee leader, member Jim Mancuso's question around Jim asked, assuming the DEA guidance is favorable, will this enable states to have trigger legislation like Washington or Oregon, which opens up interstate commerce under these interstate commerce pacts that are developing? And I want to, say the answer is yes. I think that there is an opportunity to use the appropriations process to tie the hands of DOJ to interfering with interstate commerce between states where they have these pacts, and that is legal within the two states. I'm not saying that you need to get that done this year, Michelle, but I do think that and I think under the current under a regime where Schedule 3, once we're under that regime, I think getting those sorts of things, those sorts of policies enacted will be easier. And as far as I understand, both Oregon and Washington, they're pretty vague on what the triggering moment is, which just says when the federal government allows it. It doesn't need to be legalized and descheduled. It could just be through an appropriations rider. But on SAFE, I think, I sure hope this is lighting a fire under Congress to get SAFE finally through the Senate. And I think the challenge is going to be, frankly, on the House side, given all the chaos over there. But we do, to be clear, we do have the votes in the House. We just have, they're distracted by, a lot of things, and the leadership isn't as helpful as they were under the Democratic. I'm trying to be a little diplomatic here, but they're
well. And it's interesting too, because there was, there's certainly, or I should say, it is true that under House Republicans that the rules are a little bit, the way that they've structured the rules, especially for appropriations, but particularly around House votes, they did make it easier that essentially, anyone can go up and offer it, which is nice, but you are always dealing at the discretion as well, though, of your committee chairman. And it just so happens that the committee chairman that deal in our relevant committees, especially on the House side, or I should say we're talking about the House, on the House side, are not favorable to sort of allowing amendments like that through. So Aaron, another question for you. Betsy in our Q&A board, don't forget everybody, we only have about a little bit more than 10 minutes left. So get your Q&A in, upvote those that you want to see. Betsy asks, what impact will this have on mostly small and medium businesses? Does this crack open the border for MSOs? And I think that that's sort of, something that we've been concerned about as an association. Our membership is comprised primarily of small and medium-sized businesses, and they're certainly the ones, that could have more difficulty in being compliant in a Schedule 3 world. What are your thoughts on that? And again, thinking about interstate commerce as well, too.
Well, I mean, if we're in a world where the industry is expected to be compliant with the Food, Drug, Cosmetic Act and all the requirements around Schedule 3, then yeah, certainly the MSOs have an advantage, and even there, many of them probably wouldn't get into compliance. But I don't think that's the world we're in. I think we're more likely in a world where the federal government either has a policy of deferring to either has an official policy of deferring to states, as we're advocating for, or at least continues what they're doing now, which is to just kind of quietly defer to states on this issue, even though the industry is out of compliance. And so I think I would argue this is very good for Main Street cannabis businesses. It's also good for the MSOs. It's good for everybody because it lifts the burden of 280E. The burden of 280E is so heavy on this industry that, I think most that are operating are willing to take the risk of possible FDA crackdown, because frankly, 280E, if you're operating in retail and cannabis, 280E is going to put you out of business in a couple of years probably anyway. So, what's the prospect of federal a federal crackdown look like compared, you get closed by the FDA or closed by 280E? Take the risk. And I think that's what a lot of the operators I talk to are saying. So, I'd say this is good for Main Street cannabis. It's also good for Wall Street cannabis. And I think continue to, we are Main Street cannabis, but we also understand that we are going to, continue to compete and have a free market where we can compete with the big MSOs and operate alongside them. So, I think, and I think arguably this is even better for Main Street cannabis because the smaller businesses are the ones that, bear the brunt of 280E in some ways the most. It's just the hardest, the lack of access to capital they have and, all of the other challenges that come with 280E disproportionately impact small businesses.
Aaron, another thing that I've heard a lot of people talk about, and we also had a question from Amy in the chat is about our international obligations and international treaties. There's a number of UN treaties that are around drugs. One of them is the Single Convention on Narcotic Drugs from 1961. Of course, that's about just more than a decade before we had our Controlled Substances Act come into law. And I'm curious, I think people are sort of divided on this. And again, this isn't an area where I am an expert in. I certainly lean on others that are more well-versed in this area, but I'm curious, what your thoughts are on, violating UN treaties. Right now we're not, I guess our states are violating UN treaties, because they have created their own laws. The United States as a whole, our federal law is still compliant with those international treaty obligations. But obviously, like I said, our states are certainly skirting it. And, I think about countries, for instance, there are countries like Bolivia, India, Pakistan that have carve outs for the way that they use and consume cannabis. And then also there's I should say sections in there that deal with the medical use of marijuana, countries like Germany, or others. And then of course we have countries like Canada, for instance, that are completely now not in compliance. What do you think? What are your thoughts on some of these international treaty obligations that we have? Is this something that, is a sleeper that we should be keeping an eye on?
Yeah, I mean, I think, opponents of reform always point to these obligations, say, well, this is why we can't do anything. Our hands are tied. When, the reality is we're violating a lot of treaties all the time, unfortunately. But Canada, as you mentioned, is in violation. Uruguay, other countries are, of course, the states. And, I think, the US has been the major driver behind international drug prohibition, was the driver behind these treaties to begin with. And if and when, not if, but when our government does end marijuana prohibition, which this rescheduling doesn't do, by the way, but when we do, the U.S. will then become an advocate to get these treaties changed and in the UN, and I think a very strong advocate compared to countries like certainly Uruguay or Canada. So I think that there's other good groups doing great work within the UN trying to push this along, and I think the U.S. changing our drug policy, our cannabis policy will be certainly a tipping point there.
Yeah, because a lot of these countries, and even when these are written, they were really following in a lot of ways, the US was driving these, I guess is what I should say. And I think the other important thing there is that, the UN really doesn't have any enforcement mechanism for this, does it?
No. And they're, right now, there's a scheduling system, in the treaty, and our laws and the laws of many of the other, countries that are in compliance have that same system that mirrors. And so everything is Schedule 1, cannabis, LSD, drugs like that are in Schedule 1 and so forth. That could all change. They can certainly, this is all of these things are able to be amended and changed just like anything else.
All right, let's see some of our other questions here from people. Just a few minutes left here. We'll try to get one or two more in. All right, let's see here. Nick McCormick, I see your question here. Aaron, just curious to get your thoughts. There are a group of 14 members of Congress that wrote a letter stating that recommending cannabis to be rescheduled from 1 to 3 was irresponsible. I believe that was comprised of 8 senators and 6 members of the House. Any thoughts on that? Don't follow the science unless we agree with the science.
The last gasp, I mean, yeah, I mean, I think we're going to see some pushback to this, but it's no longer the mainstream. And we're seeing even on either in either party, and I think that's certainly a sign of the times.
All right. We also had a question, and getting back to timing here, John wants us to use our crystal ball, though, Aaron, and he wants us to answer when, both in the best and worst terms, do we think we might have some answers by? I think the most positive is that maybe we'll get a recommendation from DEA by the end of the year. What do you think?
I mean, I'd say that's pretty that'd be a pretty aggressive schedule. I mean, that would be great. But I wouldn't bet on that. I think, in the next 6 months, perhaps. But I know I've heard folks say that there's, 90 days. I honestly, to be honest, do not know, but I'd be comfortable saying before the election would certainly make sense.
Yeah, and I think on the worst case scenario, and this is my best worst case scenario, I would say maybe, again, like spring, maybe end of April or something, again, keeping that administrative review process in mind, something that would allow for that 60 days to still take place, maybe even before the lame duck session, potentially, of next year. So there's our Michelle and Aaron's crystal ball for you, John. Aaron, how can people be involved? We've talked about a lot of different things. Obviously, this is an administrative review. This isn't something, at least not yet until the public comment opens up, that people can be super involved within just yet. But the work with Congress never ends. So how can people, members, non-members, get involved?
Well, I mean, the number one way to get involved is to make sure that you are exerting your influence over members of Congress. There's a few ways to do that. The easiest one, of course, the shameless plug, but it's to join NCIA to make sure that we have a seat at the table for Main Street cannabis when these conversations are happening, because there are hundreds and hundreds and hundreds of issues and thousands upon thousands of lobbyists in front of members of Congress every day competing for priority. And cannabis is only one of them. And there's only one lobbyist out there that's actually representing the voice of independent cannabis operators, and that's Michelle here at NCIA. But also get in, show up to town halls in the districts, contribute money to campaigns of members of Congress who support our issues, make phone calls to, members of Congress if they don't support our issues, or even if they do, and thank them for that, and asking them to prioritize things like safe banking, 280E relief, and these appropriations riders that we'll be talking about later, that in the next cycle, and to make sure that they understand that this industry is politically active. It kind of it blows my mind. I saw in the polls there were 25% of the attendees said they had no budget for advocacy. So I kind of wonder what's going on when you have people that sometimes invest their life savings into a business that is in contravention of federal law, yet won't spend the cost of a cup of coffee to get that federal law changed. It kind of blows my mind. And and I'll flip that around and say, while that blows my mind, I'm also just, deeply grateful for the members of NCIA that are investing in the reforms that are not only going to help their businesses, but help the entire industry. The more investment we have in reform, the faster we will get that reform, and the more we can prioritize it. So I want to encourage everybody who's not yet part of NCIA, set up a call with somebody in our team to learn how you can get involved. Also, please plan on coming out to Washington, D.C. and joining us for Lobby Days, which is an opportunity to meet with members of Congress and their staffs and talk about things like how safe banking affects your industry, or not, the lack of safe banking affects your business, I meant to say, the crushing burden of 280E, and really put a personal story to all of this, because it's one thing for Michelle to walk into an office with anecdotes and facts and figures around these things. It's a whole other thing when they hear from you. So I want to encourage all of you to attend Lobby Days next year, and also thank our sponsors that are on the screen for Lobby Days, making that possible. Leading into Lobby Days, we have our stakeholder summits that are taking place in California, Missouri, Maryland, and Colorado. This is an opportunity for members and non-members alike to show up and let their voices be heard in front of both state policymakers and regulators and federal officials who will be presenting and doing kind of a deep dive into state policies in these 4 key states in the industry. We have those happening between February and April, leading into Lobby Days, and contact us for more information about how to engage with those. But the thing is don't sit on the sidelines and think that positive change is just going to happen. I'll end with this, as I saw a couple of questions that were people saying they were paranoid or scared that the industry or that Congress is sitting down with the, big pharma, or big tobacco and big alcohol, and that the industry is going to get wiped out by big tobacco, et cetera. That's not what you should be scared of. I think what you should be scared of is an industry sitting idly by, not investing in their own interests, in the advocacy work that's needed to push the ball forward. Big tobacco, big alcohol, they're there. They've been there much longer than us, and they're smart. They invest millions and millions and millions of dollars in lobbying. And that's how they got to where they are. They're not here to crush us. They're here just to succeed. We need to make sure that we are investing in that sort of policy reform and advocacy. It doesn't happen by itself. It doesn't happen because it's the right thing. It happens because of hard work, like people like Michelle and everybody in DC that is, pushing the ball forward. So really just encourage you to get involved, and I'm happy to connect with anybody offline, even, personally, and I know anybody on our staff, to talk about the work that we're doing and how you can plug into it.
Well, fantastic. I think that that's going to be the conclusion for today's program. Thank you all so much for joining us, engaging in an active question and answer period to really drive today's conversation. And we're providing responses in advance to our intro polls so that we could get a better read of the room and learn more about opportunities for you to get involved following today's program. We're going to enable an outro poll before the majority of all of you all drop off. If you want to stick around for a few minutes and give us some additional responses to that, it will greatly inform our upcoming Policy Matters webinar, which will be broadcast to all of you all during the first week of October. As Michelle mentioned at the top of the call, we already have a sitting state regulator from the state of Maine, John Hudak, and an absolute expert on the reschedule and descheduling issue to dive deep into that. Any question that we did not answer today, please note we will be considering those. We will be following up on all of those. We'll make sure to get back to all of you all personally, and it will greatly inform our conversation in just a few weeks with John Hudak, NCIA's policy co-chairs Khurshid Khoja and Michael Cooper, and a still to be determined special guest from Congress. I know a lot of you all will be very interested once we have that firm confirmation, and really look forward to having all of your all's involvement in those future sessions. As always, I do want to close out today's program by giving you all a quick heads up about some upcoming activities that we would all love your all's involvement in. The first being the return of our service solutions series of webinars, with that edition taking place just next week on Wednesday, September 20th, featuring Zayzoon and longtime NCIA member and supporter Work. I think that Work had more employees in today's program than I've ever seen from one single member business. About a dozen signed up in advance. So thank you, Work, for all of your longtime investment in NCIA's success and our policy mission specifically. And then additionally, we do have another edition of our Committee Insight series, which is our program spearheaded and led by one of our 15 member-led committees, taking place the following day, next Thursday. This one specifically is focusing on the diversity, equity, inclusion side of these important conversations, and we really encourage you all to sign up for that session by heading to NCIA's website after today's call. And last but not least, as always, we will close out today's program by giving you all a slideshow that showcases the nearly 75 member businesses that have taken this investment seriously and have invested significant amounts of efforts into our political advocacy efforts via membership. If you are one of the 35 or so non-member companies that did let us know that you weren't a member at the top of the call, please do know that we'll be following up with you all, hopefully to schedule a meeting to talk to you about how you can get involved with NCIA's efforts and how you can join NCIA as a member. If you don't see your company included in this slideshow, make sure to follow the emails that you'll get in your inbox. And we look forward to seeing you all again for another Fireside Chat with NCIA's government relations team later this fall, and specifically at the next Policy Matters webinar, which again will be broadcast during the first week of October. Huge thank you to Michelle Rutter-Freeberg, our Director of Government Relations, as well as our CEO and co-founder, Aaron Smith, for driving today's fantastic conversation, and really appreciate all of the active engagement from the audience members and, most importantly, the NCIA members in today's audience, which really ensure that we're able to continue driving positive reform for you all on the federal side. So with that, thank you all so much for attending. Get those responses into the outro poll, and we'll see you all again next time.